Now, in this whole Ken Ofori-Atta extradition, what do you see will be at play here? Because you've played between the international arena and the local. Now we are told by the Attorney General that Ken Ofori-Atta has hired some top US lawyers to, prevent this from going through. What will be the outplay like?
That the lawyers on the US side are going to argue on his behalf that, government of Ghana's motivations is primarily motivated by political hostility. That is the only defense he could potentially have to resist this, and not only to resist it, but go through the whole appeal process, perhaps right up to the Supreme Court of America.
From all that has happened and utterances.
Yeah. Well, I think it is also a lesson for the OSP, because at one point the OSP was saying that, the US government had given the green light because, they on the face of it, they didn't think it was politically motivated. Whereas now, when we're looking at the facts, it seems that the request couldn't have been processed in terms of an extradition without a full charge sheet and supporting evidence. So this is what, the Attorney General has now done, a full charge sheet and supporting evidence. And there's all this talk online that, oh, well, his visa runs out on Valentine's Day, I think. I don't know if that's true, Valentine's Day next year. So, what's going to happen then? I think they're suggesting that, deportation, etc. But we also have to remember that Ofori-Atta is a high net worth individual by anybody's standards. And I would be at a loss if he didn't have, like a US investor visa where you invest a heck of a lot of money in the US and then they give you a green card. You never know what is at play, etc. But what I do know for sure is that the US Federal District Court judge is going to start looking at this, is going to look at if there's a probable cause, and then certify whether to extradite or not. Ofori-Atta has arguably a strong case that this is politically motivated, just because, as I think you were reading before, when the show started, you said that Ofori-Atta's US lawyers are slamming the OSP for an illegal warrant, legal breaches, an Interpol notice, and no crime identified. So they're already highlighting what the basis of this politically motivated defense will be. And he's probably got a lot of money, so he's going to take this. Should he not win that defense, which he might actually, because there's a lot of information out there to potentially show political motivation. But should it not carry, he can just go through the appeal process, etc. But it'll also be very interesting to find out if he is, who knows, a green card holder based on, I think, an EB-5 visa, because when you're a high net worth individual, you can invest, thousands, if not millions of dollars in order to get that sort of visa. And he was there for medical reasons. So, it would have been a smart move at the time.
His lawyer says, and I quote, "This is not an investigation aimed at establishing the truth. It is the aggressive pursuit of a person, not the prosecution of a crime." Amanda, if a lawyer says this, and as you've explained, there's enough for the lawyer to say this is a political persecution, right? And if you listen to what he said, there's weight behind what he's saying.
Well, he's a lawyer, so he has to talk for his money. Okay. That's the nature of being an advocate. There are, it goes on both sides. There's 78 corruption and corruption-related charges that have been levied, and I think government of Ghana presented that, full charge sheet and supporting evidence for this extradition warrant. So it goes on both sides. If they are very competent lawyers, which our Attorney General has said, which I just don't think he should have bothered saying, because we are sovereign, and so we will fight this. That is how government behaves. But, they will attach every exhibit. It will probably go into 300 exhibits, etc., to prove that this is politically motivated.
Okay.
Everything from videos to comments from the highest levels of office downwards to rhetoric to... they've got a lot of information to make a case.
Yeah.
You know, one
because at the point he says, you do not try people through press releases and tweets.
Yeah.
So it means that they are everywhere. They've been coming through all
I mean, and that is what I did spot that a bit earlier this year about this government. And I don't think they're doing it to persecute per se. I just think they're trying to find a fine line between advocacy. You know, that's why the AG's office now has a lot of press briefings, etc. They're trying to find that fine line. But should it go against them, then maybe this will be a lesson for them for 2026, 2027, that, for instance, the US Attorney General will never, ever, ever, ever have a press conference except on the morning of that charge. And then within an hour even, she has a press conference. You see what I mean? And so forth. So to vilify someone and to persecute them in terms of their personal name, because this is a name that someone builds for 20 years, 30 years in politics, etc. If you think you have such a good case, file it. You know what I mean? But until then, leave it outside the court of public opinion. And should they be chastised for this? Because, you know, Ofori-Atta's lawyers is going to see, I mean, nowhere. This is unprecedented. I mean, they've got so much material to work with about what happened before that charge sheet. You see what I mean? So it could go either way because at the end of the day, Ghana is also a sovereign nation. And we are saying there's more than 78 charges. And so we will do what we will because we are sovereign. We want our own back. Whether he is our own or he also has a green card or, you know, there's other things, we'll see.
Yeah. Okay.
Look, first things first. Everybody must know the fact, why is Ken Ofori-Atta in the U.S.? Is he in the U.S. in sunny beaches, or is he in the U.S. just walking around, not doing anything, or is he in the U.S. for medical attention? He is there, and all the records have been made available to the OSP and everybody that cares to know that he is there seeking medical attention. That's one. Two, unfortunately, we have a different legal system to the US legal system. And we are going into a system that everything that we do here, it frowns upon. The US have what you call a grand jury and a grand jury indictment. Like Amanda said, in the morning before an attorney in the US will make a statement is when they unveil the indictment, which they've gotten from a grand jury. What's a grand jury? In the US, the prosecutor takes his case, his witness, all the case he has about you, assembles a jury privately, secretly, and basically do like a mock trial of the case he or she has to the grand jury. Then the grand jury, upon hearing the weight of the case and the witness, will either find you guilty or not guilty, or indictable or not indictable. So when the grand jury indicts you, it is sealed. That means the prosecutors are confident that what they have has been put through a mock trial and is weighty. That's when they now say that you are indicted. So remember, the success rate of Americans coming to get you is 100%. Why is that? Because they've already put that witness statement, all the evidence, everything through a very strict proof process. So by the time they now come to grab you, they are going to the court in Ghana for extradition with the indictment which they know a jury has indicted you. So they've already done a mock trial on your case. We don't have a similar system in Ghana. Our system is based on one person standing up arbitrarily saying that you are a criminal. I have investigation, I have this, I have evidence. It is only put bare when we go through the trial. But it has not been tested in any of the systems that the US have. That is where it gets tricky because, like Amanda said, there is a weighty evidence that his lawyers have, including a video of armed policemen walking through his house. You've forgotten about that one?
Yes. The early days.
Yes. Armed policemen, armed military going into his house. So when you now somebody who is ill, one, because there is hospital records to show that he's ill. He's not there just in Bahamas or relaxing. Then they show the court that, look, this is the man who is in the hospital, and this is what they did in Ghana without a warrant being served on him, and look at the armed military men in his house. So, look, there's a lot that has been done by the OSP that today it's going to come back to bite him if this thing goes to anything near a court in the US. The statement that he came and made publicly and all those things, and the red notice and all those things, it's going to come back and bite him. Because the US judge will look at it clearly and say that, look, this guy is being prosecuted and because his party left office, and that is why they are doing this to him. Does Ken Ofori-Atta have something to answer in the SML? Maybe, maybe not. But I think that if there is enough evidence, right, go ahead and prosecute him in absentia. Because you have other witnesses who can testify, and his lawyers might not have him to defend himself. So the case that they need to establish is that he's not the only one being charged. The case can go ahead with the other accused people, right? And if they all come and say, oh, I did this because Ken told me to, I did this because Ken told me to, then the case now becomes, everybody is saying that they did it before Ken told them to. So then the onus is on Ken Ofori-Atta to come and answer.
But the converse is also right? Where people say, if he has nothing to hide, why not come?
No, but that's different. If I have nothing to hide.
The other argument is, if he did have something, and this is just thinking like a lawyer, but if he does have something to hide, the first thing one would do as a high net worth individual is go and find yourself in a jurisdiction with no extradition treaty with Ghana. Oh. For instance, high net worth individuals can literally buy a passport from $50,000 to $200,000 to $500,000. You can go to places like within the
Northern Cyprus.
Yes, the Caribbean, etc. But places where they don't extradite. So when people are real criminals, the first thing they do is they assemble their lawyers. They find out where you can't be extradited from. Okay. Like 0 chances. I think Cuba is also one of them.
Northern Cyprus.
Yes, and then you just pay them. You know, it's called you just pay them the amount for the passport. So it's called like a investment into the country. You can buy a passport for like $50,000 to $200,000 if you want, if that was your aim. The last place any criminal will go on this earth is America. You would definitely not fly straight to America because that's the first place that will extradite you. Oh. You see what I mean? Yeah. So these are the sort of arguments that are going to be couched by his lawyers, who our Attorney General has said are good, but he should look at himself as good rather than somebody else is good. You don't see their case, you see your case. Okay. You see what I mean? But I really believe that his lawyers are going to have such a field day with over 300 exhibits of what persecution looks like.
You know it's 300.
I mean, as a lawyer, I can assemble 50 exhibits over nothing. You know what I mean? Like over a case. But this is real meat in terms of exhibits. And they will do it because they're being paid to, so the longer hours they'll bill for. So
and let me land. You know, the issue at stake now is that, do we have a case that needs to go to court? Yes. But I have always said that the SML, is it that you don't agree with a procedural process or there is criminality? That is what you have to go to court and prove. There are other witnesses that they are in the country. Take them in and let's try and see what you get out of it. But at this point in time, I just think that they've overreached. The OSP, and there are even instances where the Attorney General has disagreed with the OSP on this matter, right? Where the OSP...
I remember the extradition one.
Thank you. So all these things are there to be played out. But look, let's just wait and see if there is a case to be answered and how, if he comes. People, like you said, people say that why is he out of the jurisdiction? Look, if you need medical attention, you need medical attention. When Ken was minister, there were times when he has to fly out on medical grounds. And all those records are there to show that he's not well.
Okay, all right. Sanjay.
To me, why are we making so much noise about Ken Ofori-Atta's case? The man told you that if you want me on Zoom, you can get me on Zoom. What prevented the OSP from even having an investigation or interviewing him on Zoom and starting the process. Because if today you were a court of competent jurisdiction was to say that Ken Ofori-Atta is guilty, and then you are going there to extradite him, people will understand. Even the American government will understand. What is your problem? Why do you want him in the country at all costs? He told you he wasn't feeling well. At times, I look at
Says there are some questions that they want to see him first.
and I'm saying that he can do Zoom.
Well, this is criminal
Look,
trial.
when
We don't do Zoom for criminal trials anywhere in the world.
Oh, okay.
But it wasn't
no,
a trial. It wasn't a trial. It was an investigation.
Yes, I
It wasn't a
moving
trial.
forward.
So investigation, you can do a Zoom.
Investigation,
You
yes.
can do a Zoom. This thing. Sedinam Tamaklo was in court by him. She wasn't here. They took her to court. The court found her guilty while she wasn't in the country. So what's wrong if even you don't want to even interview her, him? Take your findings and send them to court and start the court process.
But in that case, she skipped bail, in fairness. I think she skipped bail. That's why she
Yes,
wasn't in the country.
but the point was that she wasn't here when the trial
He
went
wasn't
ahead.
even here when the
Trial went ahead.
So we could have done that if truly we wanted our money. We weren't looking for a persecution, somebody to persecute. We don't want the person in reality to persecute, but we wanted to do the right thing. We could have done that. We are talking about money here. Look at the people that Attorney General gave nolli prosequi to. He gave nolli prosequi to his own people, amounting to a tune of more than 10 billion Ghana cedis.
He cited good reasons.
Yeah, and wait, and you are following somebody for 1.4 billion Ghana cedis. But 10 billion Ghana cedis, because they were your people, you did away with it. We are talking about Auditor General coming out with its reports that 18.4 billion was lost, mismanaged by MDAs, ministries, departments, and agencies. You are not saying anything about it. So many things in the country that we should be fighting. The government came up with promises and then campaign manifestos that Ghanaians are waiting for him to implement. These manifestos are not being implemented. All other things are geared towards Ken Ofori-Atta. Every day since the inception of their government, we've been talking about Ken Ofori-Atta, Ken Ofori-Atta, Ken Ofori-Atta. Nothing is being done. As if like they are trying to cover up. They use Ken Ofori-Atta's case to cover up for their inabilities of implementing their manifestos. That's what I'm seeing. Because you cannot be on one particular person talking about a financial loss to the tune of how much? 1 billion. And we have other people who had more than 10 billion. You told them to go. We talk about how to even cap corruption. You are not talking about that. When I see Manasseh Azure and co talking about this Ken Ofori-Atta's issue, at times I ask myself, is Manasseh Azure checking the Auditor General's report? Why is he not talking about the MDAs?
No, he's been talking about a lot of things.
I'm talking about the MDAs. Why is he not talking about he's saying that there should be a public pressure. What about public pressure on the nolli prosequi, Manasseh Azure? Why don't you talk about the public, inside the public, to put pressure on the John Mohammed's administration to take this nolli prosequi off the more than 10 billion Ghana cedis that his first administration appointees took from this country? Nurses are not being paid. Teachers have problems, and we have people who are owing this country, mismanage our resources to the tune of 10 billion Ghana, more than 10 billion Ghana cedis.
As for the nurses, I'm told they've been paid.
Not all of them. Some of them are still not yet paid, and some of them are even at home. They've not yet had their appointment from the government to come and work. So what we are saying is that with the Ken Ofori-Atta's issue, whatever the government wants to do, he is trying to even misuse our resources at the same time, going to US to go and hire lawyers, blah, blah, blah. How much is he going to use on this Ken Ofori-Atta's issue? Instead of just going to our Ghanaian courts, instead of just taking our Ghanaian courts to find him guilty, if he's guilty, it means he has to pay money for us, to us. So we can now be able to go to US. Instead of looking for lawyers to go to US to try to extradite him and those things, I don't think it is necessary. We have so many things we need that money to use in this country for. And government should not even try it. That he's going to use money to go and hire lawyers from other countries to do that.
Okay.
I don't think it is right. With Ken Ofori-Atta, it is a political case. That's what I'm seeing. If it is not political, take the Zoom that he promised you and then send your case to court. If you are right, the judge will pronounce him guilty. And you can now use that guilty certificate to go to anywhere to go and bring him to this country. But we are tired and sick of all this Ken Ofori-Atta issues in this country.
Wanda Madilo, let me come to you.
He's confused.
I'm laughing because when Jane is talking, Brace is so interested.
She's a woman. That's what women have to.
Okay.
Yeah, she's a woman.
Now I understand. But, you know, we have been left with an albatross, which are also excesses from the previous government. This whole business about OSP here, OSP there. Why didn't we hear about this OSP when he was being appointed? What accolades didn't come from the same MPP? What didn't they tell us about Martin Amidu having failed? And what didn't they tell us about this same Office of the Special Prosecutor? We thought it was going to be a smooth ride. I mean, a lawyer of that repute. I respect Kisei Jabin very well. I mean, everybody knows him within the confines of criminal law. He's done very well for himself. But I think that he got himself somewhat embroiled in the issues of being too excited about some of the cases. And I think that's where maybe his crisis began from. And government has donated so much money, so much revenue in terms of the OSP office. I remember it was supported from both ends to have an OSP. Many years ago, we were arguing about the separation between the Office of the Attorney General and the Minister of Justice office having to be separated so that we can have an Attorney General who can be, you know, doing the job of defense and all that. And then we have a Justice Minister who also does something else. But we didn't get that until Akufo-Addo, His Excellency, tried to moot this idea of having an office of special prosecutor. But I think that time has passed and we have observed that maybe upon hindsight we should have empowered an office like the EOCO to have these powers and go to court and do the prosecution. There's too much duplicity of anti-corruption agencies in this country to the extent that we're losing so much revenue in their support. You talk about SHRAG, you talk about the OSP now, you talk about EOCO, you talk about even the BNI. I see it more as an anti-corruption agency than, you know, any other, you know, office. So we are spending so much money and getting very little, you know, value for some of the things we're getting. Now, this whole finance minister's thing, I think the OSP, I won't use the word misled, but he was very excited and believed so much in his processes at the time, knowing that the laws in the US will not sanction listing somebody on the red notice and later now going to court about it. I think he should have just proceeded to court when Ken failed to show up or to honor his own, you know, because I hear a lot of people say that they're going to have a field day in the US and it's not going to be that easy. Because Ken himself on his own account had written to the OSP stating that he was in the US, he was coming at a certain date, he failed on one, said he was coming at a certain date. After that date, they haven't heard from him. His lawyers have not written back to the OSP and all that. So it's not a one-sided event where you think that the OSP has failed throughout. The culprit himself, as it were, Ken Ofori-Atta himself.
Can you say corporate?
The alleged corporate.
I did this.
Just say alleged.
I did this.
What does this mean?
Okay.
Say alleged corporate.
Oh, this means alleged.
Okay, lawyer, help us. What should we
Alleged, I know.
He said it himself, alleged.
Alleged. I know. Hey, he himself has committed himself in some of the grounds when he said that he was coming. And then, how do I trust you again? You see, it is not just that the OSP deciding to do what he's doing. It is based on some, you know, antecedent, some facts leading up to this point where we are today. In criminal trials, nobody can stand for you. No lawyer of any standing in this country will say that my client has been invited and then I'm going to represent my client. It's not done in this country.
So cannot trial in absentia?
You can try in absentia, but that is when the case has been taken to court.
Okay.
This is an investigation where you are invited to the police station or to any other office, as it were, to give account of what you know or what you don't know. Then you are held liable, and then you are taken to court, and then the process begins. In Sedinam's case, I hear people saying Sedinam was not in court, he didn't stay in court. It's not true. Sedinam was actually in court. The trial had begun. It was the judge who gave her leave to go for medical treatment abroad, and with people, of course, standing surety. And then when she went, she didn't come back. Then the court proceeded. They gave her several notices to return. She didn't come back. The court proceeded with the trial. So it's not the case that she ran away before the trial began. She was actually in court in 2021. The ruling came in 2024, if I'm not mistaken. So indeed, that was the process. I would have thought, and I think the difficulty of the OSP was that Ken wasn't showing up at all. And how do I begin the trial without him? He felt he needed his
Zoom. You gave them the option.
And
right?
I'm saying that is not within our jurisdiction.
Investigation,
not trial.
It's not done. It's not done.
Well,
you must be there in person. Please. You must be there in person.
To support what we are saying.
You can't
under the Constitution.
You are inviting me. No. If you are inviting me to ask me a question, you see, let me help you. Let me help you. There are two people in my house.
Grace, can I continue my...
Okay, he says it doesn't.
Okay, go on.
So you invited him. He gave an indication that he was coming. Later he says he's not coming. Now he wants to do Zoom. It is not in your place as somebody that has been invited by a law enforcement agency to decide or to determine how the investigation should happen. That's what I'm saying. And that's law. That's not something we're subject to debate.
But his presence doesn't mean his presence doesn't mean anything.
Number two,
he can decide
when you talk,
not to say
anytime
anything.
you talk, I'm very quiet. Just very quiet when you talk. I don't interrupt because I know that you need time to flow. Then you go ahead from that. The OSP wrote to him. He wrote back. They wrote to him again. And then there's silence. Now we don't hear anything again from him. And then occasionally you see videos, they say he's gone for some program or whatever. So that's for me, that is not of essence to me. What will play out in the US court, we are all aware of what will play out. The OSP, of course, now the Attorney General has beginning to make some input and decide to look into the matter properly. I think that two heads are better than one. If he had done this from the beginning by way of maybe a relation with the Office of Attorney General, I'm sure we would have crossed this bridge long ago. But whatever it is, whether he wins the case or the OSP wins the case, it's not what we are looking for. What is paramount is that government hasn't lost money. If at the end of the trial we discover that government hasn't lost money and nothing has gone untoward, fair. He has a right to fair trial. He has a right to freedom. He has a right to be who he is. He can go and argue that in court. Let's not belabor the point and conclude that, because this has happened and all that. Is he the first person who has been raided by the military or the police or the investigative bodies? He's not the first. They didn't go there to kill him. They went there to invite him or to bring him whatever. And force, in our law, a certain level of force is allowed when in terms of arrest. When you want to arrest, and the person proves stubborn, a certain level of force is allowed, and the law allows that to happen. So as to what force was applied, what level of the force, that will have been determined in court. And I don't think that we should be worried about what the outcome is. It's a legacy the NPP left behind of an institution that has failed to bite since it was put together some years ago. So much money has gone there. We haven't seen the value of it.
There's an angle out of...
We're trumpeting this. We're excited that they join us.
There's an angle out
of... appointed by government, because you...
Lawyer, I'll come back to you. Because I want you to address one angle of this for me before I move on. But let me bring in the WASSCE issue so that we interview someone and then we can conclude on this and deal with that one. The minister has been talking about the result of the recent WASSCE and how that is a reflection of how the students were not able to apply what they've been taught, and that this actually was probably the truest reflection of whatever they've learned in school. Let's listen to the Minister of Education. When we come back, we speak to Peter Ante.
I talk about issue now is about performance at the West Africa certificate exams. It's only in Ghana that when students pass, the students are praised. When they fail, blame a minister or blame a government. That's a paradox and an irony for me. Now, what worked out was that we strengthened supervision and monitoring, and invigilation was strengthened. But I want to believe, upon my examination of the examiner's report, that the results reflected real outcomes of what to be expected. I share this with you. There's a student whose birth date is March, secondary school completed, and the student can't spell March on his birthday, yet he passed. He got excellent aggregate. How did that happen?
It wasn't examination tension.
I say he cannot spell March.
Wow.
March. If it was necessary, maybe then you say he can't spell necessary as I probably struggle or somebody struggles spelling it. Just March. He can't spell March yet. He was born in the month of March. You've seen instances where we are told that a student beat up a teacher for refusing to give them an opportunity for exam malpractices. What does that reflect? We need to work to restore integrity in
How intentional are you about restoring that kind of integrity?
If you recall, even before WASSCE, myself and my team were in the Bono region. I spent the night between Babato, Kintampo, through Techima. It was to send a certain signal because some areas in that particular corridor were notorious for exam malpractices. And we needed to tell them that we'll come after you. And probably that worked. But what is important, after evaluating the examiner's report, many of the learners struggle with application. So maybe they prepared for just memory, memorization of concepts. But this time around, the questions focus on application of what they learned. I think that let us all commit to improving the provision of quality secondary education.
So that is the Education Minister there, Haruna Iddrisu, speaking with, she's still my colleague, Mefa Apel there. Let me bring in Dr. Peter Anti. He's Executive Director of the Institute for Education Studies and lecturer at the University of Cape Coast. Doc, I'm grateful to you for joining us. Now, the Minister clearly says, based on the investigations they've done into this, it sort of suggests that the student had issues with applying or dealing with the application-based questions. You've also dealt with this. You've looked into it. I mean, what do you make of what the minister is saying? Is he right? And if he is, what needs to be done to change?
Thank you very much, Okojo, and good morning to your viewers. If you remember, I was one of those who said that we should hasten slowly in drawing conclusions to why the students didn't perform well.
Yeah.
And I said that we should pay attention to the chief examiner's report and other works that will come out after some analysis of the questions have been carried out. And I'm glad that the chief examiner's report is informing the minister's decision. Yes, I have spoken to most core maths teachers. And one of the things that comes or cuts across their response to the challenges that the students face with the core maths was the fact that the questions were in word form instead of sometimes the normal numeric form that you would get. And when questions are placed in that way, what it means is that the student would have to first read and understand and then apply the very basic principles, whether it's indices, whether it's trigonometry, or whatever it is that they have learned, to the demands of the question before they will be able to answer. So it is true, because it's come from the chief examiner who has analyzed all the responses that are coming from the various assistant examiners and examiners. It is true that application became a big issue in the 2025 examination that the students sat for, and a lot of factors can lead to that. But the minister is right, speaking to the chief examiner's report, which WAEC has also indicated that a lot of students were not able to apply what they have learned to enable them respond to the questions that were asked during the exam.
Is it an issue of teaching, as in how the kids were taught, or is it an issue of strict supervision and how that impacts examinations?
Well, if the problem is application, then 2 or 3 factors comes to mind based on research in terms of how you analyze some of these things. The first is the teacher pedagogy. There are certain pedagogical, or let me use the normal word so that everybody will understand, teaching methods. There are certain teaching techniques that teachers need to use to be able to teach application questions. So when you want to deal with application, prepare students for application questions, you don't apply just any method. You use the project-based method, use the problem-solving method, you use the experiential learning method, you use the case study method, and other methods that gives the student the opportunity to explore various possible responses to the particular question that is placed in front of him or her. So teaching methods plays a critical role in preparing students to answer application questions, because with application questions, the student will have to dwell on his understanding of the situation vis-a-vis his understanding of the theory that have been taught, so that he can now apply the theory to the problem and then find an answer to. And that will not happen if the teacher is using a mere question and answer method, or the teacher is using a lecture method, or the teacher is using more teacher-centered methods in the instructional process. So yes, it depends on the teaching methods. And this means that clearly our intervention approaches are clear-cut. Which schools perform poorly in core mathematics, give the teachers more in-service training, professional development in some of these transformative pedagogies or creative pedagogies or innovative pedagogies that are available, that enables the students to apply what they are learning. Again, you also look at it from teacher assessment processes. What were the kind of assessment questions that these students were exposed to before the WASSCE? Were they recall, or they were, as we say, we have level 1 to level 4. Were they level 1 questions, or they were level 2 or 3 and 4, which demands higher order thinking? If they were prepared for level 1 questions, then it means that when they sit for the exams and the questions are level 3 and 4, they are going to find themselves wanting. So these are 2 issues that you can push on the teacher. Then you look at the student comprehension. Your ability to read and understand the question depends on you and not the teacher. So what is the student's comprehension level? What is the student's reading ability? And this boils down to the problem that the president talked about, foundational skills, foundational learning. How are we preparing our students in these 2 basic areas that cut across the global system, numeracy and literacy? So if students are not able to read, if the students read and they don't understand, then you give them application questions they will not be able to answer. That means that then they would have to rely on help during the examination period. So your point of strict examination, strict supervision comes in. So I can't read, I don't understand, I was not prepared for that. Then the next option for me would be, can I get help during the period so that I can still answer the question? So when you increase the level of invigilation and supervision during the exams, the student is left wanting. And that technically can lead to the performance that we experienced.
Okay. Doc, once you say the solution is clear-cut, I hope that the Education Ministry and the GES are able to implement the necessary solutions so we don't get this performance again. Thank you so much for your time today.
Thank you, Kwejo.
So that's Dr. Peter Ante there, who is the Executive Director of the Institute for Education Studies there. We'll come back to this whole discussion, but I want a lawyer to conclude on this for me, and then we can move on. Now, the lawyer for Ken Ofori-Atta, one of them in the US, is questioning the legal sufficiency of the charge. The charge sheet reportedly prepared by the OSP, noting that it fails to specify what actions Mr. Ofori-Atta allegedly took, how he personally benefited, or whether there was any intention to personally benefit or harm the state. He says these are key elements required to establish criminal liability under Ghanaian law. Is that it?
Yes, but again, you know, it's again to do with jurisdiction, because I think you were mentioning, you know, US law where you have to have, you know, this sort of mock trial before the indictment.
Yeah.
So in them saying that, you would also have to look at the standard that Ghana has. For instance, I know a lot of these charges do also relate to a company, is it SML?
SML, yes.
SML, etc. And so the presumption is that if he is personally being charged, it means that the veil of incorporation has been lifted. You know, you can only sue a company ordinarily, but with the NAM1 case, etc., we saw that if the officer is considered so bad or so detrimental to the company, you lift the veil of incorporation to go behind and look at the officers. And so they've looked behind the veil of the company and they've said, he has done this. So if our charge sheet meets the standard of what Ghana wants or Ghana has in terms of our laws for what a charge sheet is, and if the trial is therefore the appropriate forum to investigate these things, then that is a different standard to what the US standard is.
No, he's using the Ghanaian standard.
Yeah, he says
Yes.
Is that the Ghanaian?
And he's saying that is
That-
Yeah,
the court
yeah, but
what-
let me
Yes,
even correct Amanda a little. He acted as
I'm correcting the lawyer.
No, you can't.
not in law, not
Because
in law.
he's saying
He said the veil of company, which is SML.
Yeah.
Ofori-Atta's involvement is as a minister of finance, not
Okay.
on the company side.
That's why the lawyer is saying
acted
that.
as a minister of finance. So you
He's
have
saying
The lawyer is
whether there was a show of how he personally benefits from this whole transaction. Whether
Yes,
he wants
but with the charge sheet, is that what our law says about the standard that a charge sheet shows he benefited? And we have to look at the charge sheet again ourselves.
That is
I haven't
what
seen
he's
the
looking
charge
at.
sheet.
Okay.
I haven't seen the charge sheet.
Okay.
This is a lawyer's interpretation because he's going to frame anything
Yeah.
to make his client's case look
Yeah, yeah,
good.
okay.
That one.
But ultimately, when we're looking at charge sheets, it is about, for instance, the funds. You know what I mean? Because the point you quite rightly made is we're bandering this man's name around a lot, and Ghana is bandering this man's name a lot. But if your interest is in quote unquote $1 billion or whatever, then why don't you just focus on the $1 billion? Do you as government have methods to collect that $1 billion or to
Thank you
collect
very-
even beforehand?
Thank you very much.
So why is the focus on the man's name so much?
Okay.
You see what I mean?
Thank
These
you
are the
very
sort of
much.
subtle nuances that the courts in America might be considering.
All right, thank you. Yes, we are done.
Well,
We are done.
in my view, I mean, the lawyer is doing his job, but causing financial loss to the state did not include showing that you personally benefited. It talks about you being a public officer, signing a contract for and on behalf of government, and not having the required mandate to do it. And that act must have caused loss to the state. It's not about personal benefit to you. And the crime is not because he has benefited personally.
You know
It
what
has
you
to
left
do with
out?
financial loss.
Willful. You left
Willfully,
out that willful.
yeah, willfully causing.
Willful is very important in that crime.
so not necessarily
you have to
about
prove.
benefiting.
You have to prove the motive of will.
So
Willfully causing financial loss. So it's not just causing financial loss.
Yes.
That person has to be willfully.
So
that is where the catch
no,
is.
state that the lawyer's position is rather wrong. Because
Okay, all right, no
financial
problem.
loss to the state.
I mean, the court will determine how this goes. I don't know. Maybe okay. My director says my time is up. I would have given you a minute to take on the performance, but I'm sure we will have enough time.
No, that's
for the
fine. No
performance.
problem.
The
Sunday.
MPP caused this, so it's not a
The MPP caused it.
Because we
They prepare.
Amanda says, "Don't play politics with all the things." Yeah.
because
prepare the students. No, thanks.
Anyway,
I mean,
thank you very much.
for me,
Amanda
I don't talk
Clinton.
much.
Amanda Clinton is head of the Chambers Amanda Clinton Consultancy. Janet Nabla is founder of the People's National Party. Kwajo Poku is executive director of INSTEP and a member of the MPP communications team. And then Wanda Madilo is a development analyst and a member of the NDC's communications team as well.